Hello, everybody, and welcome to a new series on the subject of jurisprudence. This lesson is going to take an introduction to the subject of jurisprudence, talk about some of the ways in which we define the subject, some of the major theories of the subject, the importance of this subject, as well as the scope of the series that we are going to be covering over the next weeks and months on the Law Academy. Now, this is the first lesson to the subject of jurisprudence. Now, we are going to ask essentially the following questions, okay? We're going to be asking the first question, which is probably the most pertinent for an introduction to jurisprudence course, which is, what is jurisprudence? That is something that is going to be important for us to explore and examine and to really get our heads around at the start of this series of lessons. We're then going to talk about why jurisprudence is important. This is often a question that is asked by law students specifically. Now, because this is an open course for anybody who wants to have a look and to watch this content, this might be content that is consumed by law students. It might be content which is consumed by other students. So, for example, philosophy students. And so, as a result of this, the ways in which you view jurisprudence may be indicative of which subject you are particularly studying. For a lot of the time, and for a lot of people, the subject of jurisprudence is one that is seen by at least law students as not particularly relevant or important, and then at least by philosophy students is considered to be more important. So really, how you view jurisprudence at the outset is something that can be indicative of your general approach. Now, as a result of that, I would encourage anybody and everybody who is watching this lesson who is studying or maybe has a background in any of these subjects to put in the comments down below straight away what your initial thought process and understanding and attitude towards jurisprudence is at this early venture. Do you think that jurisprudence is important? Do you think it is a very useful and very important, as I said, and vital part of study? Or do you think that it is actually useless, not important, and is just a tick boxing exercise that you have to do as part of your university course? I'd be very interested to see how these attitudes actually lie on the kind of law versus philosophy spectrum, whether or not you're a lawyer or a philosopher. And I sort of have an idea in the back of my mind already as to what, depending on what subject you're doing, what your general approach to jurisprudence will be. We will also talk about some of the most important theories of jurisprudence, arguably the two most important theories, one of them being linked to the person who is pictured at the top of the screen here. Again, for those of you who want to engage with this lesson in a bit more detail, put in the comments down below who the person who is at the top of this screen actually is, and I'll pin and I'll like and I'll heart the right answer at the bottom of this YouTube video. And then I'll finally think about and talk about the scope of this series, okay? So what we're actually going to be covering in this series, but also what's important as well is what we're not going to be covering. What areas of jurisprudence are not going to be part of the scope of this series. Let's begin. What is jurisprudence? Now, just like with a variety of different parts of law and different areas of philosophy, sociology, criminology, the concept of jurisprudence, in inverted commas, isn't one which is necessarily easy to define. It is a thing that you study and that you understand more than a thing that you define. We can get an etymological definition, i.e. what the word and the derivation of that word comes from, but that doesn't necessarily give us any indication as to how that word is used and how that word is defined in today's colloquial understanding of the English language. Now, things are made worse with the word jurisprudence because the word jurisprudence is often used, at least within the context of the legal tradition, to refer to two different things. It can be referred to as case law. So, for example, if I'm talking about international law, public international law, I might refer to the jurisprudence of the International Court of Justice, the ICJ, and that would be referring to the various cases and the various precedents that are established by the International Court of Justice, or jurisprudence within the context of the criminal law, within the common law jurisdiction of England and Wales. Again, that refers to case law. But that's not the kind of jurisprudence that we're going to be talking about in this series. That is the kind of jurisprudence that is going to be dotted around all of our lessons on all of the various topics relating to both domestic and international law, as well as European law as well. In fact, what we're going to be talking about in this series of lessons is the idea of the philosophy of law, or legal theory, or legal philosophy, however you want to define it, however your university defines it, however your particular textbook defines it. So we're going to be focusing on the latter of these two definitions in this series of lessons, and avoiding the idea of case law, talking about the idea of the philosophy of law instead. Now, ultimately, if we go to Blackstone's Law Dictionary, we can see from Garner in 2009 that the concept of jurisprudence and this kind of the tradition of jurisprudence that we understand today is sort of born out of the 18th century, the 1700s. And this will become very clear when we start to look at one of our major theories of jurisprudence, this being legal positivism. We'll see that some of the most important approaches from both the legal and the philosophical side of jurisprudence comes out of the 18th century, comes out of the works of people like John Austin, John Stuart Mill, Jeremy Bentham, etc., etc., which are sort of it sort of bridges the gap between law and ethics, law and philosophy, law and politics. And so as a result of which, our modern understanding of where jurisprudence comes from derives out of the 1700s, the 18th century, should I say. And despite this, however, it should be noted that even though our modern understanding and the sort of development of jurisprudence comes out of this period, the idea itself of jurisprudence and some of the most fundamental philosophical principles of jurisprudence pertaining to the idea of rules and the idea of laws are actually far more ancient than that. The first of our major topics on the idea of the natural law comes out of the works of individuals such as Aristotle, and then into the sort of Christian and the Christianization and the Catholicization of academia and the intellectual movements. And this is, of course, what takes place in the ancient times as we transition from ancient history into the sort of early medieval period. So even though jurisprudence is a 18th century development, shall we say, the theories themselves derive and are far, far older than that. Now, jurisprudence in this context would therefore be defined as, say, the philosophy of law, or the theory of law, or legal theory, etc., etc., etc. And so, for all intents and purposes, this is actually a philosophical course, but it is one that is important for any law student who is also looking to have a deeper and richer understanding of the law as well. And this is really where we get into the question of why we should study jurisprudence. What is the purpose of studying jurisprudence? If you are somebody who is a law student, you might think, well, I don't really want to study jurisprudence. Why do I have to sit in a seminar room and discuss the philosophy of law when I could go and revise the criminal code? I can go and revise various tort cases, and actually these are going to be more important to me in the real world as a corporate solicitor in London. Well, in reality, jurisprudence is very, very important, and it sort of bridges the divide that we could say exists between the descriptive and the normative study of law, because the vast majority of your studying of law, especially in law schools in and around the world, as I know in great detail, is focused on the descriptive realities of law. If you are doing an undergraduate degree in law in the UK, for example, you will take exams where you will just be given a problem question and you'll be told to apply the law to that problem question. It's a very descriptive endeavour. It is essentially asking you to identify the issues at hand and to apply the law to those issues. It's not particularly very normative. It is asking essentially, what is the law? How does the law work? How do we apply the law? That is essentially it. Now, if you go to maybe a better university in the United Kingdom or elsewhere around the world, you might also have the ability to challenge the fundamental nature of law. And one of the ways in which you can do that is through the study of jurisprudence, because jurisprudence and any other theory of law and legal theory invites us to challenge the fundamental nature of the law and ask not necessarily descriptive questions, but in fact ask normative questions. So we could be asking asking questions such as what the law ought to be, what should the law be, why is the law right or wrong in this particular context, why is one case here more controversial than this other case. And then the next question is, what fundamentally is the law? Now you might be thinking, well, that's a sort of descriptive question. Why would I be studying that in jurisprudence? Well, when we talk about what fundamentally is the law, we're not asking the question as to what is the descriptive nature of what a particular law says. So when I say what fundamentally is the law, I'm not asking, for example, what does it say in sections 27 and 28 of the Land Registration Act? I'm actually instead talking about law as a general abstract entity. What actually is law? What does it mean for something to be law? What is the law fundamentally at this deeper and richer understanding? That is a question which is, as you can probably imagine, far more philosophical in nature. I've already mentioned the two theories that are going to be cited on this slide already, but I'm going to do it again just for the purposes of this particular lesson. As mentioned previously in an earlier slide, I noted that despite the fact that the jurisprudence that we understand today comes out of in and around the 18th century, and that in fact the first time the word jurisprudence is cited in English language is around the late 1600s, these ideas and theories are often based on theoretical approaches to philosophy which date back as far as the ancients, so people like Aristotle. And in my mind at least, there are two important theories, and this is really where we're going to spend the majority of our time studying jurisprudence. We're going to talk a lot about natural law theory, and we're going to talk a lot about legal positivism. Essentially, natural law theory is where seemingly a lot of the earlier approaches to law have derived and developed, and then legal positivism is one that kind of came onto the scene and has had a huge impact and has had a huge influence over all of jurisprudence to this very day. So we're going to be spending a lot of our time talking about natural law theory, legal positivism, the strengths and weaknesses of each of these theories, the history of each of these theories, as well as the variations within each of these theories coming from different philosophers. So essentially, that's going to take us to looking at the scope of this series. Now, the scope of this series is going to be looking at the following structure. Now, this is the same structure as you would find in any jurisprudence or philosophy of law textbook. Now, I'm going to be citing the various references and citations and bibliographies at the end of each of these videos, in the description of each of these videos. I'm going to be following 2, 3, even 4 different sources in order to construct these lessons. But ultimately, every single jurisprudence textbook or philosophy of law textbook that I have seen, at least, covers these topics in roughly this order. It seems to be the standard, a bog standard order. It's the same way that, for example, negligence is the first tort that you study in any kind of torts textbook. So we're going to begin, for example, by talking about natural law theories. This is where, for the most part, people begin to talk about jurisprudence. On account mainly of the age of natural law theory, because natural law theory dates back, as I've said, to ancient philosophy. We're going to divide this topic into 3 main lessons. We're going to talk about the ancient influences, the definition and origins of natural law theory. We're going to talk about the impact of Christianity on the natural law movement, so that means moving into the more medieval part of natural law theory. And then we're going to finish by looking at how natural law theory influences and impacts jurisprudence to this day, by looking at some of the more modern theoretical approaches to the subject. We will then talk about arguably the most important of the jurisprudential theories, depending on where you sit in terms of the philosophy of law, this being the concept of legal positivism. We're going to be talking about the origins of legal positivism and the influence of philosophers such as that of Austin. We'll also be talking about various critiques of Austinian legal positivism, the approaches that Austin actually took when it came to approaches relating to positivism. We will then talk about the influence of arguably arguably, at least in my opinion, the most important jurisprudential philosopher of all time, potentially, that being the work of H.L.A. Hart and his approaches to legal positivism. We will then talk in the final 2 lessons about the critiques of legal positivism which were levied and presented by the likes of Dworkin, and then finally the influence of Joseph Raz on the legal positivist movement. This does not mean we're going to be finished with these 2 theories, however, because we're going to then talk about law and society. Law and society focuses on sociological and post-liberal approaches to legal theory. This means talking briefly about Durkheim and Weber. Weber, not that much, given the fact that he doesn't actually cite that much about law in his writings, because he's a sociologist. And then we'll talk about Marxist interpretations of law. We're going to keep the Marxist interpretations of law in this section to just the traditional Marxist understanding of law. So we're going to just talk about what, for example, Marx and Engels said about the legal traditions within this topic, because then in the final topic we'll talk about further alternative theories, which essentially builds on those Marxist interpretations of law by talking about modern Marxist and anarchist approaches to legal thought, talking about feminist approaches to legal thought, and then building upon both of those and talking about postmodern influences on legal philosophy, which includes critical legal theory as well as critical race theory, which is, of course, the most controversial of all of them, at least in recent times, the most controversial of all the theories of jurisprudence and the philosophy of law. This is the major structure of this series of lessons, and I want to just finally end on what is absent from this series, because despite the fact that this is a jurisprudence course, we are not going to be diving into too deep the issues relating to the philosophy of specific areas of law. So, for example, I'm not going to talk in too much detail about the philosophy of human rights or the philosophy of criminal law. This is not because they're not important, but it's because I believe they merit their own subject and conversation, their own separate series of lessons, because they are far more detailed and far more interesting. And potentially after we have studied this general jurisprudence course, we might go into and dive into, for example, the philosophy of human rights law, because then we can build upon our understanding that we've learned from this course and then start to talk about how that applies to those areas as well in future lessons' time. In this lesson, we're going to talk about natural law. We're going to introduce this major first topic within our subject of jurisprudence, just taking a general introduction to the subject of natural law theory before going into some of the more important details, history, and modern interpretations of natural law theory in future lessons' time. So, like I said, we're introducing the first subject of our philosophical inquiry. This is the interpretations of law as described through the lens of the natural law tradition. We're going to look at what law is in relation to this idea of morality, the necessity for a theory of natural law, as well as some of the early origins of natural law theory. And then in the next lessons, we're going to talk about the ancient origins of natural law, deriving out of some of the Platonic and Aristotelian writings, and then focus on arguably the most important period where natural law really flourishes, which is, of course, in the early medieval period of the theological doctrines of people like Augustine and Thomas Aquinas. So, the first question that could be asked and ought to be asked in the context of any conversation about not just natural law, but just the theory of law and the nature of law is the question of how law is linked to the concept of morality. Some of you might think that it is. Some of you might think that law and morality are inextricably linked together in some kind of way. And you could be correct in making that assumption. You are definitely not alone in making that assumption. And the reason for that is, in a lot of cases, you can make the argument that law regulates moral principles. Why is it the case that murder, for example, is considered to be wrong? Well, it's considered to be wrong because of its immorality. And obviously, murder is regulated by law. So you can make that connection. This is not to suggest that there is a one-to-one comparison or that law only regulates morality, but just that there is somehow potentially some kind of link that exists between the idea of moral principles and moral philosophy and the idea of law and legal theory. According to the philosopher, the legal theorist H.L.A. Hart, who we're going to get to in a lot of detail in future lessons' time, he argues that the concept of law is, or at least in the concept of law, he argues that and asks the question, how does legal obligation differ from and how is it related to moral obligation? So how are these things both interlinked and how are they different? What is the differences? What are the similarities? Now, the question that we have to ask before we respond to the question that H.L.A. Hart proposed, the question about whether or not law is linked to morality, what are the similarities and differences? The first question we have to ask in trying to tackle the answer is to think, well, what is morality? And if we're going to talk about the nature of law and its relationship with morality, then we probably ought to think about what morality is. And this is really where we start to see and derive some of the principles of the natural law. Because in the broadest sense, what we talk when we understand what morality is just an understanding about acts and omissions which are said to be right or wrong or good and bad. It's putting a value on your act and or omission. It is putting a value of a moral value. It is putting a moral value about whether or not that thing was good or bad or whether it was right or wrong. Now, morality is delineated between the descriptive and the normative. And now, what does this mean? Essentially, morality and moral philosophy have inherently within them both descriptive and normative dimensions. Now, when we talk about it as being descriptive, we say that morality is descriptive in the sense that it seeks to explain what it takes for good and bad behavior to be identified. Okay, so if I was to outline and see an action that is committed by an individual, I can then put a label onto that as to whether or not it was good or bad. If I see a murderer or I talk about somebody who has committed a murder, I can label that action as good or bad. I will often label that action as bad. And so therefore, I have put a descriptive identifier on what the morality of that particular action was, or that particular person. That person is immoral. That person is bad. It then also has normative dimensions, in the sense that this description then guides one to develop answers to how we ought to behave. So we're not just describing what an action is or isn't, whether or not an action is good or bad. We're also then saying what actions ought to be described as good or bad, how we ought to behave on the basis of our understandings and preconceptions of morality. All these ideas and the interlinking between natural law and moral philosophy and the idea of what morality ultimately is brings into the fold this idea of the natural law. When we talk about natural law theories, we note that these theories will place a certain amount of moral weight to the ideas and principles which are then further encoded within the law and the legal systems. Lawmakers and legal scholars are subjected to a set of moral values in the creation, development, and interpretation of law. And so what natural law essentially notes that the law ought to do more than just simply exist outside of the confines of morality. Natural law theory, as applied to jurisprudence, doesn't just tell us that law and morality are separate. They argue that essentially there ought to exist law within the specific confines of moral philosophy. It ought to contribute to the development of moral standards, and that this morality is that what we utilize to define what law is. So when we think about another first introductory question within jurisprudence, the question of what law is, when is a thing law? According to a natural law theory, we would say that it is law if it adheres to the moral principles and standards which are consistent with the natural law. According to Finnis, who is a more modern natural law scholar and who we will get to in future lessons' time, he broadly defines natural law as a system of law which is based on a close observation of human nature and based on values intrinsic to human nature that can be interpreted and applied to the positive development of law. This is a little bit of a wordy and convoluted description, but this is essentially what natural law theory tells us. Now, there are different variations and different influences of natural law theory, which we're going to get to in the future lessons on this particular topic. But for now, let's just finish by talking about what this definition is really telling us. It is a system of law, and that the system of law and the determination of what constitutes law is based on the close observation of human nature, and is based on values which are intrinsic to human nature. And so we have to see that there is a certain amount of objectivity here. There is an intrinsic value, moral value, which is placed on human nature, which the natural law subscribes to, and that we interpret this intrinsic value and apply those moral principles to the creation of new laws and the positive development of law in the future. In the previous lesson, what we did was introduce our first major jurisprudential theory, and this is, of course, the theory of natural law. Natural law often comes first when we discuss and when we're studying jurisprudence, for a number of reasons. One of them being, obviously, it is the oldest of the major theories of law that we can think about. And now this lesson is going to start to talk about some of the ancient origins of natural law. So we're really going to be dividing our lessons of natural law into three main time periods. We're going to be talking firstly in this lesson and in the next lesson about the ancient origins of natural law, talking about the likes of Plato, and then more importantly and specifically Aristotle and his influence over the natural law tradition. And then in the second set of lessons looking at the history and the development of natural law, we're going to talk about the impact that theological thinkers have had on the natural law theories. So we'll talk firstly about Augustine and how Augustine takes something of a Platonic interpretation of natural law, and then we'll talk about St. Thomas Aquinas, who takes more of an Aristotelian interpretation of natural law, mainly because, of course, Aristotle's writings had not been discovered when Augustine was writing, but they had been discovered by the time Aquinas was writing. And then finally, we'll talk about the modern interpretations of natural law, the most important being that of Fuller and Finnis. And we have the sort of procedural natural law theory, and then we also have a theory of natural rights. And then we will move on to looking at legal positivism. So, like I mentioned, the previous lesson introduced the subject of natural law. It also gave some basic definitions of what we mean when we talk about the idea of natural law, examining the relationship between law and morality, this inherent relationship that exists within natural law theory that doesn't necessarily exist in other jurisprudential theories such as that of legal positivism. That's not necessarily to suggest that legal positivism does not take into account morality at all, but just it exists on the peripheries of their legal theories compared that to natural law. This lesson, like I've said, is examining some of the origins of the natural law theory, talking about its ancient development in the Greco-Roman period. Now, in terms of theories which become natural law theories that we know today, we find their origins mainly within the antiquity of ancient Greece, specifically within the kind of classical period of ancient Greece, or sometimes known as classical Athens or classic Athens, which is, of course, the period where we have events such as the Peloponnesian War. We have events such as the writings, the lives, the life and therefore, and also the trial and death of Socrates, as well as the founding of the Academy with Plato and Aristotle, all of these different ideas. And this is where natural law develops, specifically develops firstly with Plato and then more so with Aristotle in the next lesson. So the reason why we're beginning with Plato is because while Aristotle is considered to be the key founder of the natural law tradition, Plato would be a heavy influence on pretty much all of Aristotelian thinking and Aristotelian thought, not only for areas and ideas where Aristotle appears to agree with and take on board some of the Platonic ideas within philosophy, but also because Aristotle in a lot of instances disagrees wholeheartedly and almost completely contradictory against that of Plato's ideas. And so these two ideas and these two philosophers can sort of bounce off each other in terms of how we understand the development of ancient Greek philosophy. So let's think about Plato's theory of law. Now, what Plato's understanding of law looks like is something akin to something as a moral obligation, and his theory of law is very similar to his ideas of moral obligation. It has a number of different elements to it. We have this idea of the concept of law and the sort of substance of law as articulated in the Republic, and then we also have another period of his life that is important to understand, and the influence that this period of his life has over his theory of law. And this is the idea of the death of Socrates and the impact of the death of his tutor, who was, of course, Socrates. Now, before we continue in any great detail, I would just like to make it very clear that Plato's writings are, for the most part, a dialogue format, in a kind of response, question and response kind of format. They are viewed as conversations, often between Socrates and a number of other thinkers, and so the Republic is a debate, it's a dialogue, and it's very, very fun for new philosophy students to actually engage with Plato's dialogues, because you can sort of do it like a play. You can have one person speaking, playing one role, another person playing another role. And the idea here is the kind of question and answer back and forth that eventually leads us to conceptualizing different philosophical ideas. So really, Plato doesn't necessarily write in the first person as himself. He writes conversations between Socrates and other individuals. Now, we're going to try and spend more time looking at the philosophy and jurisprudence rather than the specific history of ancient Greece and the specific histories of Plato and Socrates. So, for the most part, all we really need to know for these lessons is that Socrates was the tutor and the mentor of Plato. Plato was then the tutor and the mentor of Aristotle, and then Aristotle would go on to become the tutor and the mentor of Alexander the Great, interestingly. And so you can see the kind of development and influence of different philosophical ideas through this chain of causation. The Republic, however, is the one of, if not the most famous of the Platonic dialogues. For the most part, if you were to ask an ancient historian, you would say that Plato does not use his own words in his own writings. He doesn't write in the first person. There are some debates as to whether or not certain texts which are attributed to Plato are actually attributed to Plato and actually are Plato's own writings, but for the most part the dialogues are not his own first person writings. They are more conversations between others. So we would write in the form of a dialogue between others, as I mentioned, so most of the time it being Socrates debating various other members of the group on various different topics, ranging from metaphysics to ethics to the philosophy and politics of the Athenian state. And in the Republic specifically, Plato presents a debate about what is the proper functioning of the state, talking about the Greek city-state in this regard. So we're talking about ancient Athens, we're talking about Sparta, for example, and other sort of Greek city-states that existed. And he talks about the ways in which we can organize the state and the best methods for doing so. And he came to the conclusion that the best way to organize the state was through the implementation of what is known as a benevolent dictatorship. And this informs his theories and ideas of where the positive law fits into this broader conversation. He believed that people ought to be trained from birth in the art of politics and statehood, as well as within philosophy, and become what are known as philosopher kings, who exist as dictators within the city-state system and will rule the people and will have the correct and proper qualifications to rule the people in this way. So the philosopher king would be one which is not necessarily encumbered by the legalistic modes and formalities that are in place to tie them down. Contrast this, however, with the way in which we understand, or at least one of the ways in which we understand law as it operates in the world today. So the law of a state not only implements modes and methods by which individuals should behave and be regulated within society, but it also regulates the ways in which the leaders within society ought to behave, especially within sort of some of these civil law systems, or even within the sort of codified constitutional systems of, for example, the United States, where the US Constitution has very, very strict, very, very clear rules on how members of Congress or the executive branch or the Supreme Court may be able to behave, and how they, and if they don't behave, the kinds of consequences that are in place to deal with them, essentially. And so what Plato argues is that with the idea and the implementation of benevolent dictatorship and the implementation of the philosopher king, you would not need to have these legalistic modes and formalities in place, and so the law would not be around to be able to essentially limit the ability of the philosopher king to do things, to make decisions. And so in this regard, we can get an understanding of how Plato understands law. He takes something of an anti-legalistic interpretation of jurisprudence. So essentially what this means is he does not factor the law too much into his broader normative framework, the broader framework about what ought and ought not be done when it comes to the proper functioning and regulation of the city-state. If we look at this passage here, we see that no legislator ever seems to have noticed that in spite of its being open to them to use two methods, compulsion and persuasion, they never mix in persuasion with force when they brew their laws. It seems obvious that the reason for the legislator giving persuasive address was to make the person to whom he promulgates his law have a greater readiness to learn. This is a very interesting passage. The reason why this is a very interesting passage is because what it does is it positions the law not necessarily as a method of coercive control, something that people are forced to follow but not necessarily wanting to follow, but instead as a tool for the education of individuals in virtues of lessons in philosophy, in the education of political functionings, the effective functioning of the city-state, and lessons in virtue more specifically. And so as a result of this, if Plato believes that laws can be utilized to teach the masses about the nature and value of wisdom, they must be in and of themselves good. And this is quite an interesting point, because when we get to the trial and the execution of Socrates within Plato's life, we see that Plato has to reconcile with the fact that there does exist legal mechanisms and legal methods that are implemented and instigated, which are considered, at least in his opinion and in the opinion of many, to be unjust and immoral. So if he believes on the one hand that the laws ought to be utilized not for coercive control, but to teach the masses about the nature of wisdom and the value of philosophy and virtue, then they must therefore be good. How does he then reconcile that with one of the most pertinent events in his life, which is of course the execution of Socrates, whereby the process by which Socrates was executed, the trial and the execution of Socrates, was one that is considered to be unjust and immoral. So that's why the death of Socrates plays quite heavily as a factor in his life. Ultimately, Socrates was put to death following a trial with accusations being made that he had been effectively corrupting the youth. Okay, he was found guilty, and as part of his execution, he was forced to drink hemlock, which is a type of poison. It's believed he was going to drink hemlock. Now, what's quite interesting about the death of Socrates is that essentially he did not necessarily have to be executed. In fact, some of the sort of the individuals who were in part, or at least part of the process by which he was tried and found guilty of his accusations, would have sufficed with sending Socrates into exile. It's actually the fact that Socrates himself chose death that is quite valuable and interesting. And the death of Socrates can be seen in various different dialogues and writings from Plato. We see, for example, in his Apology and also the dialogue Crito, we see the full extent of Socrates' trial and the impact that it had on this idea of the obeying of legal rules, even if they may be coercive, unjust, or immoral. And it appears from the trial that Socrates, if he were to comply, he could have escaped execution and taken punishment by exile. And as noted in these dialogues, what Socrates does is present an argument which seems to purport to this idea that one ought to oblige and have an obligation to follow the positive law. So even where law may be particularly unjust or immoral, there is this idea of following the law regardless. You have an obligation to obey legal rules, positive legal rules. Now, Socrates uses three main points, I believe in Crito, to make this argument, to show that one ought to obey the positive law. He makes an analogy to that of a parent versus a child, arguing that people are like children, they ought to obey the parent, and in this regard the parent is situated as either the sort of ethereal concept of law, or maybe the lawmakers that are in charge of the city-state, and they should do so out of a sense of gratitude to the law and the maintenance of the system of the state. Socrates also makes the argument that by staying in the state, there exists certain laws that you may disagree with, which may even be unjust or immoral, you are implicitly accepting obedience towards such structures. So this is essentially a roundabout way of saying, if you don't like it, you can always leave, as a way of being able to understand how the obligation to follow the rules exists. If you wish to essentially challenge the law that you believe is unjust or immoral, you ought to either push to have it changed through legal and democratic means, or you can just simply leave, essentially. And given these two purposes, the person who disagrees with the law can either persuade to a reform to the law or move to someplace else, or the final option is to simply just obey the law and exercise your obligation to obey the law. Welcome back, everybody, to our subject on jurisprudence. We're continuing looking at the development of natural law theories from the sort of ancient origins with Plato and Aristotle, going through to the sort of medieval period where we talk about the impact and the influence of theological principles with that of St. Augustine and St. Aquinas. And then we're going to move on to the modern theories with Finis and Fuller. But for now, we're going to talk specifically and keep our attention to that of the ancient theories of natural law. And we're going to focus on the idea of natural law developments through the Aristotelian age, through the age of Aristotle and his interpretations of natural law theory. So, like I've just mentioned, we looked in the previous lesson at some of the fundamental ideas pertaining to specifically the origins of some of the principles of the natural law. We looked and took a lot of time with a detailed examination of the likes of Plato and the way in which Plato influenced theories of natural law and the importance of law and legal obedience. This lesson is going to move on from Plato and look at the works of Plato's student, of course, being that of Aristotle. Now, when we talk about natural law theories, for the most part, people tend to focus a lot of their time on Aristotle and then Aquinas. And what we seem to get the understanding of there is that Aristotle was the sort of founder and inventor of natural law theory, and then Aquinas takes up the Aristotelian principles and applies it with some sort of, at least for Aquinas, the sort of modern theological approaches. But in reality, people tend to miss quite a lot of the work that was done and the foundations that were laid by people like Plato in the ancient period, and then St. Augustine of Hippo in the theological early medieval period. And so we're going to make sure that we spend our time looking at Plato and Augustine as well as Aristotle and Aquinas. So as a brief recap to what we looked at in the previous lesson, we were looking, as I mentioned, at Plato and Plato's theory of law. And what we did was we noted that Plato's theory of law actually played quite little into his broader understanding of the idea of the proper functioning of the city-state. So in one of his major works, the Republic, or Plato's Republic, we see a lot of dialogue going back and forth about the effective and proper role of the functioning of the Greek city-state. Of course, this was written and was taking place during the life of Plato, where we have a number of different things that take place within what is colloquially understood, at least within classics, is understood as classical Athens. So we have things like the Peloponnesian War, we have things like the life of Socrates, the life of Plato, and the life of Aristotle. And during this period of ancient Greek history, we see, of course, the formation of the city-states, the states such as that of Athens and that of Sparta, for example, the two most famous at least. And so, for the most part, when we look at the Republic, we're talking about the formation and the foundation of a proper functioning society and the way in which the city-state ought to operate. And Plato believed that the city-state ought to be organized on the basis of philosopher kings, the idea of there being sort of benevolent dictatorships, people who were trained from birth in the ability to rule through statehood and instill values of virtue, ethics, and wisdom. And with that in mind, we get this understanding that the law, the idea of positive law, is something that plays very little into the role of Plato's understanding of the proper functioning of the city-state, because for Plato, the most important thing was the philosopher kings, the ability to rule through this idea of a benevolent dictatorship. Now, Aristotle would take a different approach to his theory of law, and it's actually this Plato-Aristotle dichotomy that you can sort of see in the theological interpretations of natural law with the Augustine-Aquinas dichotomy that exists. Now, it's not necessarily Augustine's fault that he doesn't take on Aristotelian interpretations, because Aristotle's works weren't rediscovered until after the death of Augustine, and really Aquinas manages to instill a lot of Aristotelian principles in a lot of his theories of theology, not just natural law. But what Aristotle does is take a completely different approach to his theory of law and actually look at his idea of human nature. And what the most important thing that we should note is that the Aristotelian form of natural law theory in this sense is what we call teleological or teleological, depending on your pronunciation. Now, all this effectively means is referring to the importance of the end goal of a particular thing. Telos is the sort of Greek translation of the word end. And so when we say that something is teleological, we're talking about it having some kind of, the importance of it being reference to the end result of a particular thing. Now, if we were to apply teleological and teleology language to that of, for example, normative ethics, we might say that consequentialist theories of ethics are teleological because they focus on the end goal, they focus on the consequences of an action, and that therefore determines the morality of said action. And so as such, Aristotle understands law in this regard as being part of a broader conversation about the telos of human nature, about the end result, the purpose of human nature. And so with this in mind, Aristotle believed that not just humans had its own teleology, but actually all things in reality had their own teleology. So, for example, the telos, the teleology for a seed, is to grow into a plant, or to grow into a tree, for example. The teleology for a baby animal is to grow and become an adult, and that this end result is very important in informing the ways in which we understand the initial state of that particular thing. So the way we understand the nature of seeds and baby animals is with reference to their teleology, with reference to the ability for them to become something else, to grow into a plant, to grow into an adult. And for humans, the human nature, and human nature specifically, the teleology here involves an understanding of reason. He believes that humans were specific and unique in their ability to reason. And in The Politics, a book that I'm looking at right now, which I have on the shelf from when I researched this lesson, Aristotle argues that one of the teleologies for humans is the ability to develop into what he described as political creatures, animals which have social and political understandings, and that these social and political understandings were necessary, were important, and required to fit into the broader political structure of what he described as the city-state, Athens, Sparta, etc., etc. He defined the city-state as the polis, or the polis, the political structure of the city-state. So this is quite interesting for our understanding of law and our understanding of human nature as well, in fact. So Aristotle understands human nature as being inherently tied to the teleology of developing into political creatures, having social and political understandings, and being able to fit into the broader city-state political structure and to become a polis. Now, when we start to then instigate things relating to ethics and things relating to what makes something good and bad, teleology is important here as well, because the understanding of a thing's development into its telos, into its end result, is understood by Aristotle to be a good thing. Aristotle argues that not only is this a descriptive claim, is it a descriptive claim that a seed develops into a plant, but Aristotle also believed that it was normative in its framework. It should also be an ought statement. Not only is it the case that seeds develop into a plant, but that telos, that end goal, is something that should take place. It ought to be the case that seeds develop into plants. And then so applying this to more complicated structures like human nature, we can see that the telos for humans and for human nature and their ability to reason goes from being the descriptive, in the sense that the actual telos itself, the teleology itself, is the development into political creatures. But it is also the fact that it is a good thing, that it ought to be the case that people, human nature, leads to a development into political creatures. And so the achievement of the telos is the achievement of a particular kind of good. And as a result, anything which contributes to the development of a thing's telos, of the teleology of a particular item, is also seen as good. So, for example, if we look at the teleology of seeds again, one of the things that can help with the development of a seed's ability to achieve its telos is to add water and sunlight. And so as a result of which, these sort of subsidiary ideas, these sort of these sort of attachments, things that go along with the development of a seed into a plant, are also good because they contribute to and further the development of a seed's telos into its end goal. And so, a result of this, we can understand that things which develop a particular end goal, a particular teleology, it has its own teleology. And that own teleology is the promotion of the original teleology. You can almost understand this as a kind of sub-teleology. So the pouring of water onto a plant has its own end goal. It has its own teleology. And that end goal is to allow the plant to develop and grow, the seed, to develop and grow into a plant. So the teleology, the telos of that particular action, is informed by the telos of the item in question, the seed growing into the plant. So given all these influences, you might be wondering, well, what the hell has law got to do with any of these factors and any of these ideas? Well, if we then think about how law fits into things, we see that Aristotle believes that law fits into the contribution to the establishment of a human nature by looking to and contributing to the development of human nature's telos. So one of the things that Aristotle believed, therefore, was that when we look at what good law is and what a good law may be, we look at the contribution that that law has to mankind, the teleology towards mankind. And so what this does is it grounds the meaning of law, and more importantly, and specifically, the meaning of what good law is, and what law is fundamentally, as having the ability to contribute to the development of a social structure. And for human beings and for human nature, as being political animals, being able to and be capable of living and thriving within the polis or the polis of a Greek city-state. So that's what Aristotle believed the teleology of law to be one of these sort of sub-factors which contributes to the broader teleology of human nature. And unlike Plato, Aristotle actually spends very little time exploring the nature of legal obligation, talking about this idea that there being a requirement that one obeys the law. And to be fair, one of the reasons why Plato even talks about this idea of legal obligation is because of the impact of the trial and execution of his tutor and mentor, Socrates. And so, ultimately, the reason why we see quite little time explaining the nature of legal obligation under the writings of Aristotle is because he was concerned more with the nature of what made law law, what made law good law, and the justification for the existence of law instead. And so when we then go from Aristotle to one of the most influential theorists within human history, but also one of the theorists who is most heavily influenced himself by Aristotle himself, this being St. Thomas Aquinas, we will start to see this Aristotelian influence start to become very, very important. It's very clear to see just how much Aristotle influences St. Thomas Aquinas and how this develops into a more substantial theory of law, a theory of natural law, which is then imbued with the doctrines of Catholic theology.